President, today the Supreme Court Chamber of the ECCC continues its proceeding in order to announce the final judgment on the appeals by Nunchi and Keo Sampon and the co-prosecutors in case 002/01 dated 19 September 2007 with the co-accused Nunchi and Keo Sampon. Graffier, please report the attendance of the parties and the counsels. Please turn on the microphone. Graffier, Mr. President, for today's proceedings on the final judgment delivery in case 002, all parties are present and the two accused are also present. We have the co-prosecutors and the lead co-lawyers and all the defense counsel. We also have more than 100 civil parties who are attending to the pronouncement. However, due to the limited seats available in the courtroom, we only have 10 civil parties who are selected to be present in the courtroom. They are Sudni, Su Suthivi, Chao Ni, Kum Hoon, Supan Sawani, Yim Sawan, Ning Sakon, Tang Sokha, Sain Si Buddha, and Yam Rumdul. Thank you. President, I would also like to make an announcement that on the pronouncement of the summary of the Supreme Court Chamber judgment, the accused may use the restroom without informing the chamber in advance. Summary of Supreme Court Chamber judgment on appeals in case 002/01. On 7 August 2014, the trial chamber of the ECCC rendered its judgment in case 002/01, finding the accused, Nunchi and Keo Sampon, guilty of the crimes against humanity of extermination, encompassing murder, persecution on political grounds, and other inhumane acts, comprising forced transfer, enforced disappearances, and attacks against human dignity. The trial chamber found that these crimes had been committed in the course of 3 sets of events, which were the subject of case 002/01, namely, during the evacuation of Phnom Penh immediately after the fall of the city on 17 April 1975, so-called Population Movement Phase 1, during population transfers that had occurred between 1975 and 1977, so-called Population Movement Phase 2, and the execution of former Lunar soldiers and officials at a locality called Tulpu Chirei in Pusat province in late April 1975. The trial chamber found that although neither of the accused had committed any of these crimes with their own hands, they were nevertheless criminally responsible for them based upon the mode of liability called joint criminal enterprise, as well as because they had planned, instigated, aided and abetted, and, in case of Nunchi, ordered these crimes. The trial chamber sentenced both accused to life imprisonment. The trial chamber also granted, in part, the request for moral and collective reparations of the civil parties and endorsed 11 projects in this regard. Nuon Chea and Khieu Samphan, as well as the co-prosecutors, filed appeal briefs and separate and responses thereto. The civil parties also made written submissions. The Supreme Court chamber held a hearing on 2nd, 3rd, and 6th July 2015 to examine 3 additional witnesses. On 17 November 2015 and from 16 to 18 February 2016, it held hearings to hear the oral submissions on the appeals. The Supreme Court chamber then retired to deliberate on the appeals. Today, the Supreme Court chamber is delivering its judgment on the 3 appeals. At this hearing, I shall summarize the reasons of the Supreme Court chamber and read out Supreme Court chamber's disposition. The summary is provided to assist in understanding the court's decision. It does not form part of the reasons for the decision. The full judgment of the court is the only authoritative document. The appeals brought by Nuon Chea and Khieu Samphan comprise 223 and 148 grounds of appeal respectively, which often overlap. For that reason, I shall address the 2 appeals together, as is done in the written judgment. The co-prosecutor's appeal will be addressed separately. I would like to emphasize that because of the large number of grounds of appeal that have been raised, I shall at this hearing summarize only the findings in relation to those grounds that were particularly contentious or significant or of particular interest to the public at large. Of course, the Supreme Court chamber has also analyzed all other grounds of appeal that have been raised. The Supreme Court chamber's findings in respect of all these grounds are set out in written judgment. The full written judgment will be notified to the party shortly after the hearing is closed. It is a full written judgment and not my summary that is authentic. Appeals of Nuon Chea and Khieu Samphan. The grounds of appeal raised by Nuon Chea and Khieu Samphan may be divided into 5 thematic groups. I shall address each of them in turn. Fairness of the proceedings. The accused raised several arguments challenging the fairness of the proceedings against them. I shall limit my summary to 2 sets of arguments. Right to an independent and impartial tribunal. Notably, the accused submits that their right to be tried before an independent and impartial tribunal has been violated. The Supreme Court chamber is not persuaded by the argument that the trial chamber's purported bias is demonstrated by what are alleged to have been erroneous and illogical findings. Nor is the Supreme Court chamber of the view that the interview Judge Cartwright gave in 2013 discloses bias on her part. As to the argument of a lack of independence, based on the statements made by former co-investigating judge Marcel Lemong in his book, the chamber notes that those comments are of a general nature and were not stated in relation to case 002. Turning to the allegation by Tate Sambat that potential witnesses did not testify due to security concerns, the Supreme Court chamber notes that while this is a serious allegation, it is unrelated to the question of whether the trial chamber lacked independence. With reference to the arguments that the reasoning of the Cambodian judges for not calling Hein Samrin as a witness disclosed their lack of independence, the Supreme Court chamber considers that it is not obvious that this could be the only possible conclusion, since it could have been genuinely motivated by the apprehension of the irrelevance of his expected testimony. Rights to an effective defense. Nuon Chea and Khieu Samphan raised several arguments in support of their claims that their rights to an effective defense was violated, for example, by the trial chamber's failure to summon certain witnesses. With regards to Hein Samrin, Nuon Chea has requested several times that he be summoned to testify, including before the trial chamber. The trial chamber could not reach the requisite majority for calling Hein Samrin as a witness. While 3 judges considered that summoning him was not warranted, 2 judges were of the view that Hein Samrin was a relevant witness and should be called. The Supreme Court chamber considers that the trial chamber's exercise of discretion regarding Hein Samrin was unreasonable. Notably, the 3 judges who did not consider that he should be called stated that calling him to testify might cause considerable delays. In the view of the Supreme Court chamber, this was erroneous because there was no indication on the record that Hein Samrin would not appear if asked to do so. Furthermore, the request to call Hein Samrin had been made early in the proceedings, and there is no indication that whatever issues may have arisen, they could not have been resolved in the course of the proceedings before the trial chamber. The Supreme Court chamber reaches the same conclusion in respect of Ok Bun Chuen, whose appearance as a witness Nuon Chea had also requested. The next question for the Supreme Court chamber to address is whether the accused were actually prejudiced by the trial chamber's error. In this regard, the Supreme Court chamber notes that neither of the 2 witnesses appeared to be in the possession potentially exonerating information that other witnesses did not have, to the extent that Hein Samrin in a previous interview had made statements regarding the Khmer Rouge's policy toward Lon Nol soldiers. The Supreme Court chamber considers that the notes of this interview indeed raised issues that could have been clarified through testimony. Nevertheless, the interview notes were before the trial chamber and could be taken into account. In sum, the Supreme Court chamber considers that it has not been established that the trial chamber's failure to call Hein Samrin and Ok Bun Chuen resulted in a grossly unfair outcome in the judicial proceedings, warranting a reversal of the accused's conviction. The accused have raised numerous other issues in relation to the fairness of the proceedings, and have also argued that the internal rules were unconstitutional. Having considered the parties' submissions, the Supreme Court chamber has rejected all these arguments for the reasons set out within the written judgment. Trial chamber's approach to the evidence. The second thematic area concerns the grounds of appeal relating to the trial chamber's approach to the evidence. limiting opportunities for investigations at trial. The accused argue that the trial chamber erred by limiting their opportunities for investigations at trial. The first issue is whether the trial chamber erred when confirming that the defense was not entitled to investigate. The Supreme Court chamber finds that while the ECCC's procedural framework does not envisage fully fledged party-driven investigations, there is no statutory basis or compelling practical reason for prohibiting the defense from undertaking, subject to certain conditions, actions aimed at discovering relevant evidence, in particular to allow the defense to make substantiated requests for investigative action by the relevant organ of the ECCC. The second issue is whether the trial chamber erred in its disposal of requests for investigative action. The Supreme Court chamber sees no unreasonableness in the trial chamber's overall approach, considering also that any procedural defects during the investigation were cured by the closing order, permitting witnesses to review prior statements and to confirm their contents. The next issue concerns the trial chamber's decision to allow witnesses to review their prior statements before they appear to give testimony. The Supreme Court chamber considers that it would have been more consistent with the Cambodian practice not to adopt such a procedure. Nevertheless, the Supreme Court chamber does not find that the trial chamber abused its discretion given the circumstances of the case. Admission and use of written evidence in lieu of oral testimony. The accused also challenged the trial chamber's approach to the use of written statements in lieu of oral testimony. In particular, the trial chamber decided that, under certain conditions, evidence in the form of written statements or transcripts is admissible even if the defense did not have the opportunity to examine their authors. The trial chamber consequently admitted 1,124 written statements and transcripts. Firstly, the Supreme Court chamber considers that the right to confront witnesses is not absolute. An entirely unfettered right to examine witnesses against the accused would bear the risk of compromising a court's ability to render justice in a case with the size and complexity as the case at hand. Secondly, the accused contests the weight that the trial chamber assigned to the written statements. The Supreme Court chamber notes that the written statements must generally be afforded lower probative value since the parties could not examine the witnesses who provided them. The trial chamber did indeed state that the trial chamber took this principle into consideration in the evaluation of evidence, and therefore no error was made in this respect. However, a more complex issue is whether the trial chamber relied too heavily on out-of-court written statements in respect of certain findings it made. The Supreme Court chamber will analyze this question in respect of the specific findings. Reliance on civil party evidence. As to the next set of grounds of appeal concerning the trial chamber's reliance on evidence provided by the civil parties, the Supreme Court chamber is not persuaded by the arguments put forward by the accused in this respect. Firstly, while tribal parties have a special status in the proceedings, this does not mean that they cannot testify. The weight given to their testimony will be assessed on a case-by-case basis, also taking into account the fact that they were not required to swear an oath. Additionally, the trial chamber did not err by relying on so-called statements of suffering or victim impact testimony, since it was clear that they could contain information relevant to the guilt of the accused. The accused have raised several other arguments in relation to the trial chamber's approach to the evidence. For instance, its reliance on expert witnesses and certain practices in the courtroom when witnesses were asked to comment on the documents. These and all other arguments have been carefully assessed by the Supreme Court chamber, and its findings are set out in the written judgment. I have now completed the summary relating to the topic of the trial chambers to approach the evidence. I will move on to set out the findings relevant to the substance of the case, namely the crimes for which the accused were convicted.
Findings relevant to the crimes for which the accused were convicted. As mentioned at the beginning of today's hearing, the charges in case 002/01 concerned alleged crimes in the course of 3 sets of events: the evacuation of Phnom Penh, also referred to as population movement phase 1, the transfers of people starting in the second half of 1975 and extending into 1977, the so-called population movement phase 2, and finally, the alleged killing of Lunol soldiers and officials at Tulpojre. The trial chamber found that in the course of these events, several crimes against humanity had been committed. As stated, the 2 accused did not commit these crimes directly. Rather, according to the trial chamber, those crimes had been carried out by other Khmer Rouge, but they could be imputed to the accused. As a result, the analysis of the accused's criminal responsibility may be divided into 2 broad elements. First, the actual crimes that were committed by the Khmer Rouge, and second, the question of whether the accused can be held criminally responsible for these crimes. Murder. Definition of mental element of murder. In relation to the crime of murder, the first issue that I would like to address relates to a legal question, the definition of the mental element. The accused submit that murder as a crime against humanity requires that the perpetrator acted with direct intent to kill, in the sense that it was his or her objective to cause the death of another person. It is argued that the trial chamber erroneously defined the mental element as encompassing reckless murder, or to use the civil law terminology, murder with dolus eventualis. The Supreme Court chamber, after having reviewed the relevant case law, finds that the trial chamber did not make an error in this regard. Criminal responsibility for murder, therefore, may arise even if the perpetrator acts with less than direct intent. Factual errors regarding murder. The remainder of the grounds of appeal relates primarily to the trial chamber's factual findings as to the incidents of murder committed in the course of population movement phase 1, that is, the evacuation of Phnom Penh and at Tuol Po Chray. However, first, the Supreme Court chamber has to address the question of whether the trial chamber was obliged to establish individual incidents of killings beyond reasonable doubt, a question the Supreme Court chamber answers in the affirmative. Accordingly, in order to establish that the Khmer Rouge committed a murder, individual instances of killing must be established beyond reasonable doubt. On this basis, the Supreme Court chamber has carefully reviewed the factual findings that the accused have challenged. The Supreme Court chamber concludes that some of the individual findings of murder were not reasonably established, primarily because they were based on out-of-court evidence or evidence of insufficient probative value. Nevertheless, a sufficient number of killings were reasonably established based on the evidence that was before the trial chamber. Therefore, it was reasonable to conclude that the crime against humanity of murder was committed during the evacuation of Phnom Penh and at Tuol Po Chray. Extermination. Turning to the crime of extermination, several grounds of appeal relates to the precise definition of this crime. First, the accused challenged the trial chamber's finding that for this crime's mental element, a showing of dolus eventualis is sufficient. There is merit in this argument. Upon a detailed review of the relevant case law, the Supreme Court chamber concludes that unlike for murder, extermination requires a demonstration of direct intent to kill on a large scale. Thus, the trial chamber's definition of the mental element of extermination was in part incorrect. The accused also submit that a large number of people would have died in any event, and that there was no indication that during the evacuation of Phnom Penh, the number of deaths exceeded the normal mortality rate. The Supreme Court chamber rejects this argument, given that, as held by the ICTY, a wrongdoer must take the victim as he finds him. That said, the Supreme Court chamber considers that it was unreasonable to conclude that the mass element of the crime of extermination had been established in relation to the evacuation of Phnom Penh. Based on the evidence that was before the trial chamber, only a relatively small number of deaths may be considered as having been established beyond reasonable doubt. Due to the weakness of the evidence before the trial chamber, it was not possible to extrapolate that killings had occurred on a massive scale. In addition, the trial chamber relied on a dolus eventualis standard, which is, as explained before, is insufficient for the crime of extermination. As for population movement phase 2, the Supreme Court chamber considers that several instances of death were reasonably established. Nevertheless, the evidence was insufficient to allow the trial chamber to reasonably extrapolate that killings occurred on such a large scale as is required for extermination. In addition, the trial chamber's findings could not establish that the perpetrators acted with direct intent to kill on a large scale, but imply that they acted with dolus eventualis, which, as noted before, is insufficient for the crime of extermination. For these reasons, the Supreme Court chamber concludes that the trial chamber erred when it found that the crime of extermination was committed during population movement phase 1 and population movement phase 2. However, the Supreme Court chamber recalls that in relation to phase 1 of the population movement, it has confirmed that the crime of murder was committed. In relation to phase 2, although the crime of extermination was not established, the facts found to have existed by the trial chamber and confirmed on appeal fulfills all ingredients of the crime of murder, and the Supreme Court chamber therefore has decided to enter a conviction on that basis. Turning to dual perjury, the accused challenged the trial chamber's finding that at least 250 Lonol soldiers were killed in April 1975. The Supreme Court chamber is not persuaded by these arguments, as the trial chamber established the minimum number of deaths in keeping with the principle of in dubio pro reo. Also, there can also be no doubt that the perpetrators acted in this case with direct intent to kill on a large scale. In sum, the deaths and the killings occurred during population movement phases 1 and 2 must be classified as the crime against humanity of murder. The killings carried out at dual perjury amount to extermination. Other inhumane acts. The trial chamber found that during population movement phases 1 and 2, the crime against humanity of other inhumane acts in the form of forced transfer and attacks against human dignity had been committed. In addition, the trial chamber found that during population movement phase 2, the crime was committed in the form of enforced disappearances. The trial chamber approach to the crime of other inhumane acts. At the outset, the Supreme Court chamber notes that the trial chamber's approach to the crime against humanity of other inhumane acts discloses confusion in that the trial chamber defined elements of forced transfer and enforced disappearances as though they existed as separate categories of crimes. Instead, the trial chamber should have focused on whether, taken as a whole, the conduct in question was similar in nature and gravity to other recognized crimes against humanity. This requires a holistic and case-specific analysis, which the Supreme Court chamber has carried out on appeal. Circumstances during population movement phase 1 and its unlawfulness. The accused disputed the trial chamber's findings regarding the conditions and the use of force during the evacuation of Phnom Penh. The Supreme Court chamber considers that overall the findings were reasonably made, although certain generalized findings were unreasonable and not sufficiently backed up by the evidence before the trial chamber. The Supreme Court chamber is not persuaded that the trial chamber erred in its determinations regarding the purported justifications for the evacuation of Phnom Penh. To a large extent, the accused's arguments merely present an alternative interpretation of the evidence, which was short of establishing unreasonableness. Circumstances during population movement phase 2 and its unlawfulness. The accused also challenged the trial chamber's finding with reference to population movement phase 2. The Supreme Court chamber recalls in this regard that population movement phase 2 comprised the transfer of people in various parts of the country and over a long period of time. In light of this fact, certain generalized findings of the trial chamber were unreasonable because they were based upon an evidentiary basis that was too narrow. Nevertheless, it was not unreasonable to find that there was general lack of food, water, and hygiene facilities, as well as a lack of medicine and medical assistance. There was also sufficient evidence before the trial chamber to find that some people disappeared and others died because of the conditions of the transfer. In contrast, it was unreasonable to find that the overwhelming majority of the transferees were so-called new people, that is, former city dwellers, as there was also evidence referring to the transfer of so-called old people. Whether population movements phases 1 and 2 amounted to inhumane acts in the circumstances. As mentioned before, it falls upon the Supreme Court chamber to assess whether population movements phases 1 and 2 amounted to the crime against humanity of other inhuman acts. In relation to population movement phase 1, the Supreme Court chamber recalls that it was established that at least 2 million people were forcibly evicted from Phnom Penh in terrifying and violent circumstances and without prior warning. It was also established that in the course of the evacuation, people were killed and died because of the conditions that were inflicted upon the population. The Supreme Court chamber considers that in these circumstances, the evacuation of Phnom Penh caused serious mental and physical suffering and injury and affected a large number of individuals. It therefore amounts to the crime against humanity of other inhumane acts. During population movement phase 2, at least 300,000 to 400,000 people were forced to move. This finding was not disturbed on appeal. Further, the Supreme Court chamber upheld the findings that those people who were displaced endure poor conditions resulting from lack of food, water, and hygiene facilities. Some families were separated. Some deaths occurred during the transfers. The Supreme Court chamber considers that these circumstances, which affected a large number of people, are sufficient to amount to the crime of other inhumane acts. Persecution. The trial chamber found that the crime against humanity of persecution was committed in the course of population movement phases 1 and 2, as well as at Tulpo Chre. The victims of persecution were Lunol soldiers and officials, as well as the civilians living in the city of Phnom Penh at the time of its evacuation, so-called 17 April people or new people. Definition of persecution. The accused challenged the trial chamber's definition of persecution. According to the trial chamber, the group that is the object of political persecution may also include groups whose members do not necessarily hold any common political views, but who are persecuted because of the perpetrator's political agenda or motivation. The Supreme Court chamber does not consider that the trial chamber erred in this regard. It recalls that in the Dutch case, it held that the victims must belong to a sufficiently discernible group that is defined by the perpetrator on political, racial, or religious grounds. In particular, groups may be made the subjects of political persecution because the perpetrator perceived them as potential opponents or otherwise as obstacles to the implementation of a political agenda. New people as a sufficiently discernible group. The accused further submit that new people were not a sufficiently discernible group and that the trial chamber applied an inconsistent definition. The Supreme Court chamber is not persuaded by these arguments. New people included all those who were living in Phnom Penh on 17 April 1975, irrespective of whether they had been living in the city for long periods of time or had only recently sought refuge in the city. Persecution during population movement phase 1. The Supreme Court chamber further considers that the entire population of Phnom Penh was subjected to evacuation, as all were considered to be new people. This does not mean, however, that the targeting was indiscriminate and thus incapable of amounting to persecution. New people were targeted because of who they were perceived to be, and what they were seen to represent. The accused arguments in this regard were therefore rejected. Persecution during population movement phase 2. In relation to population movement phase 2, the Supreme Court chamber is not satisfied that, as held by the trial chamber, the evidence shows that the vast majority of transferees had been new people. As such, it has not been established that the transfer was in fact discriminatory. Therefore, the trial chamber erred when finding that persecution was committed during population movement phase 2. Contextual element of crimes against humanity. The Supreme Court chamber also dismisses the grounds of appeal that revolve around the contextual element of crimes against humanity. The detailed reasoning for this finding are contained in the written judgment. Individual criminal responsibility. Turning to the accused's individual criminal responsibility, the overarching question is whether the crimes committed can be attributed to the accused. The trial chamber found that the accused were criminally liable based on the basic form of joint criminal enterprise, so-called JCE-1, as well as liable due to their planning, instigating, and aiding and abetting these crimes, and in respect of Nuon Chea only for ordering the crimes and on the basis of superior responsibility. Joint criminal enterprise. The accused raised several grounds of appeal in relation to their liability based on JCE. Existence of liability based on JCE1 at the relevant time. Notably, the accused challenged the existence of liability based upon JCE1. They submit that under customary international law as it existed at the time, liability was limited to joint contributions to specific crimes, and that merely making a contribution to the implementation of a common purpose was insufficient to give rise to individual criminal responsibility. The Supreme Court chamber is not persuaded by these arguments. Even though the term JCE was coined by the ICTY, the underlying notion had already emerged in the post-World War II case law. Notably, after World War II, accused were convicted of crimes they had not committed with their own hands, because these crimes had been encompassed by a criminal common purpose to which the accused had made a contribution. The Supreme Court chamber underlies that the common purpose must be criminal in character. This means that either it must in itself amount to the commission of one or more crimes, or the implementation of the common purpose must involve the commission of one or more crimes. In this regard, the Supreme Court chamber notes that the trial judgment relied on a somewhat different formulation. Notably, the trial chamber inquired whether the common purpose, among other things, resulted in the commission of a crime. This suggests that the trial chamber was of the view that crimes that generally resulted from the implementation of the common purpose could be imputed to the accused, even if these crimes had not been part of the common purpose. In the view of the Supreme Court chamber, this would amount to the type of liability that has been referred to as JCE3 or extended JCE liability. The question is thus whether, under customary international law as existed in 1975, liability could be imputed for crimes that merely resulted from the implementation of a common purpose but were not encompassed by it. In this regard, the Supreme Court chamber notes with approval the decision of the pre-trial chamber on this question, which found that such liability did not exist at the time. Having considered the relevant jurisprudence, the Supreme Court chamber concludes that there was indeed no basis under customary international law for liability for crimes not encompassed by the common purpose. In light of this finding, it becomes of great relevance to identify the criteria in order to determine which crimes are encompassed by a common purpose. In this regard, the Supreme Court chamber finds that a common purpose amounts to the commission of a crime if the crime is one of the primary objectives of the common purpose. In contrast, a common purpose involves the commission of crimes if the crimes are not the immediate goal of the transaction but are seen as a means to achieve an ulterior objective. Whether a crime was encompassed by the common purpose is primarily a question of fact. Relevant factors will be, for example, the overall objective of the common purpose and the likelihood that it may be attained only at the cost of the commission of crimes. In sum, The trial chamber made an error in its definition of the legal elements of JCE liability. It falls then on the Supreme Court chamber to assess whether the elements of JCE liability properly interpreted and nevertheless fulfilled.
Definition of the common purpose. Turning to the next set of arguments, the Supreme Court chamber considers that liability under JCE 1 requires that the common purpose be criminal in nature. In contrast, the trial chamber found that the accused agreed to a common purpose which it described as not criminal in itself, that is, the implementation of a rapid socialist revolution in Cambodia. Nevertheless, this common purpose must be seen in the context of the Khmer Rouge's policy of population movement and the policy of targeting Lon Nol soldiers. These policies, according to the trial chamber, were utilized to bring the socialist revolution in Cambodia to fruition. While the trial chamber did not state that these policies were actually part of the common purpose, it is nevertheless clear that they were considered by the trial chamber as the means through which the socialist revolution was to be implemented. Thus, while the trial chamber's findings may be perceived to be lacking in precision, there can be no doubt that it was the criminal aspects of the two policies that was at the core of case 002/01. For that reason, the Supreme Court chamber rejects the accused's argument that the purpose which the trial chamber had identified was non-criminal and therefore could not give rise to liability under JCE. Assistance and content of population movement policy. Several grounds of appeal challenge the trial chamber's findings as to the existence and content of the policy to move the population, both from cities to the countryside and from one area to another. As to the policy to evacuate cities, the Supreme Court chamber cannot see any error in the trial chamber's findings that the policy was demonstrated inter alia by a consistent pattern of evacuations, particularly since the trial chamber did not claim that all evacuations followed exactly the same method of operation. Referring to the policy to move people from an area to another, the Supreme Court chamber also finds that the accused's arguments are without merit for the reasons explained in the written judgment. Crimes encompassed by common purpose in relation to population movement phases 1 and 2. The next issue to be addressed is which crimes were actually encompassed by the common purpose in respect of population movement phase 1. This summary addresses only the Supreme Court chamber's findings relating to the crime of murder, as this was the most controversial issue. The Supreme Court chamber finds that the common purpose encompassed the killing of high-ranking Khmer Republic officials. It also involved the death resulting from the conditions that were imposed during the population movement and the killings of civilians and former soldiers. This is because in the circumstances, the members of the JCE were aware of the conditions which the evacuees would have to endure, and that it was likely that, in particular, the most vulnerable would die. The Supreme Court chamber records that the evacuation concerns the entire population of Phnom Penh within a short period of time and during the hottest period of the year. As to the killing of civilians and lower-ranking Khmer Republic soldiers and officials, the Supreme Court chamber notes that the evacuation of Phnom Penh was carried out in a very short time span and by heavily armed troops. These circumstances indicate that, implicitly, the common purpose also encompassed the prospect that deadly force could be used by the troops who were tasked with evacuating the city should they encounter any resistance. This is the case irrespective of whether specific orders to kill were given, who gave such orders, and whether such orders were only given to troops under certain commanders. The next question is whether murder was among the crimes encompassed by the common purpose in relation to population movement phase 2. Given the circumstances under which the transfers were carried out, there is no indication that there was a policy to provide sufficient care for the transferees or protect them from abuses. The occurrence of death amongst the transferees was therefore likely, yet the members of the JCE engaged in the implementation of the common purpose nonetheless. As such, the policy to move the population encompassed implicitly the crime against humanity of murder. Existence and content of the targeting policy. The trial chamber found that there had been a Khmer Rouge policy to target former Lonol soldiers and officials, which involved the killings at Tulpu Chre. The trial chamber relied on the Khmer Rouge statements and orders, as well as the existence of a consistent pattern of executions. The accused challenged the trial chamber's findings in this regard. The Supreme Court chamber notes that, in respect of a pattern of executions existing before April 1975, the trial chamber placed significant emphasis on the alleged killings at Udong in 1974. However, for the reasons fully explained in the judgment, the Supreme Court chamber considers that the evidence on record was too weak to support such a finding. The remaining evidence of killings in the period before 1975 was also relatively weak. As to evidence of killings in the period immediately before and after the events at Tulpu Chre, the Supreme Court chamber considers that it was generally weak, except for a few instances. Similarly, in relation to the alleged killings in late 1975, the trial chamber relied on evidence that often lacked detail and primarily consisted of uncorroborated out-of-court statements. The Supreme Court chamber is similarly unsatisfied with the other evidence relied upon by the trial chamber. including Khmer Rouge speeches, policy statements, and other instructions. In sum, the Supreme Court Chamber considers that the evidence before the trial chamber was inadequate to reasonably substantiate a finding that at the time of the events at Tulpu Chray, there had been a policy to kill all Lon Nol soldiers. Most of the evidence consists of out-of-court statements which have low probative value. Moreover, the trial chamber failed to consider several pieces of evidence which call into question the existence of a blanket policy to kill. The Supreme Court Chamber recalls in this context that as a consequence of the severance of proceedings in case 002, the scope of case 002/01 is restricted as far as it concerns the targeting policy to the events at Tulpu Chray, which took place at the end of April 1975. The final result of the analysis is inevitably affected by this temporal limitation, which caused a large proportion of the evidence to be temporally irrelevant due to the trial chamber's inability to demonstrate why instructions issued in 1976 and later imply that a policy had existed in April 1975. For the foregoing reasons, the Supreme Court Chamber finds, based on the evidence that was before the trial chamber, that it was not reasonable to find that a policy contemplating the execution of Lon Nol soldiers and officers existed at the time of the events at Tulpu Chray. Accordingly, the accused cannot be held criminally liable for the crimes against humanity which were committed at Tulpu Chray. Legal standard in respect of contribution to the common purpose. Regarding the legal standard in respect of the contribution to the common purpose, the accused submits that the trial chamber failed to establish that they had made a contribution to the commission of criminal acts, but merely found that they had engaged in activities generally aimed at the implementation of a socialist revolution in Cambodia. The Supreme Court Chamber considers that the trial chamber generally articulated the correct legal standard in that an accused's contribution must be significant but not necessarily indispensable. The trial chamber also correctly considered that a contribution to the JCE may take many forms. Even activities that are prima facie unrelated to the commission of crimes may be taken into account when determining whether the accused made a significant contribution. That said, determination should always be based on an assessment of all activities of the accused persons that the chamber has found to have been established. In sum, the Supreme Court Chamber finds that the trial chamber did not err by taking into account activities of the accused that were, on their face, not directed at the commission of specific crimes. Nuon Chi's contribution to the implementation of the common purpose. The trial chamber identified two types of contribution by Nuon Chi to the implementation of the common purpose. The first is his involvement in the planning of the common purpose. The second lies in his role in activities regarding propaganda, education, and public training. Nuon Chea raises several grounds of appeal against these findings. The Supreme Court Chamber dismisses some of these grounds of appeals because they do not have the potential to invalidate the judgment. For example, his challenge to the designation as a brother number 2. In respect of other grounds of appeal, the Supreme Court Chamber considers that Nuon Chea is merely offering alternative interpretations of the evidence. This concerns in particular the finding that he had considerable influence on military policy and that he had, along with Pol Pot, ultimate decision-making power within the party. In contrast, the Supreme Court Chamber considers that the evidence was insufficient to reasonably establish that Nuon Chea was in charge of party discipline. Nevertheless, the Supreme Court Chamber does not consider that this error affects the trial chamber's conclusion that Nuon Chea had made a significant contribution to the implementation of the common purpose. Contribution of Khieu Samphan to the implementation of the common purpose. With reference to Khieu Samphan's contribution, the trial chamber identified the following activities. First, he had attended meetings of the standing and central committees and party congresses, as well as meetings to disseminate Khmer Rouge policies through lower cadres. Second, he participated in economic matters within the Khmer Rouge regime. Third, he made public statements in support of the common purpose and policies of the Khmer Rouge. Finally, he acted as a diplomat to garner external support for the Khmer Rouge. Khieu Samphan alleges several errors in the trial chamber's findings. The Supreme Court Chamber considers that most of these findings were reasonably reached. However, it was unreasonable to find that Khieu Samphan had attended a meeting in June 1974 at which the evacuation of Phnom Penh was discussed. Given that the trial chamber did not explain why it rejected the detailed testimony of Nuon Chea to the contrary. Similarly, the trial chamber erroneously attributed a speech that was made in 1976 to Khieu Samphan. Despite these erroneous findings, the Supreme Court Chamber finds that the trial chamber's overall conclusion regarding Khieu Samphan's contribution was not unreasonable, having regard to the totality of his actions. Finding that the CPK was a unified, hierarchical party and that the armed forces involved in the evacuation of Phnom Penh were unified. The accused argued that the trial chamber erred when it found that the CPK was a unified and hierarchical party, given that there were indications that from early on the party was divided into powerful factions which subsequently escalated. They submit that no reasonable trier of fact could have concluded that Pol Pot and Nuon Chea had shared a common purpose with some of the zone leaders who were inciting rebellion and treason against them. The Supreme Court Chamber is not persuaded by these arguments. It recalls that the accused were found to be criminally responsible based on joint criminal enterprise. Therefore, even assuming that a secret plot by some of the zone leaders existed, This would not mean that the crimes imputed upon the accused could not be imputed on the other members of the JCE as well, as long as it has been established that there was a common purpose of which the crimes formed part. Error of law in respect of requisite intent. As to the requisite intent of JCE liability, Khieu Samphan submits that the correct standard is intent to effect the common purpose. In the view of the Supreme Court Chamber, the trial chamber's finding that the intent must cover both the common purpose and the crimes it encompassed is correct. Khieu Samphan further argues that the trial chamber erroneously applied a lower standard because it assessed whether he had been aware of the substantial likelihood of the commission of crimes. In that regard, the Supreme Court Chamber considers that substantial likelihood is not, as such, the correct standard. However, the appropriate standard needs to be determined based on the specific crimes that are at issue. For instance, for the crimes against humanity of murder, the requisite mental element is either direct intent or Julius eventualis. Thus, if murder is committed through a joint criminal enterprise, it is sufficient to establish that the accused was aware that the death of the victim was a possible consequence of the implementation of the common purpose, but proceeded to implement it regardless, having accepted the possible occurrence of death. Thus, the trial chamber's reference to the standard of substantial likelihood was not per se erroneous, but it will depend upon the crime in question. Nuon Chia's intent. As to the specific findings to Nuon Chia's intent in respect of the crime against humanity of other inhumane acts, there is no doubt that Nuon Chia acted with direct intent. Indeed, he acknowledged that he had participated in the decision to evacuate Phnom Penh. Turning to murder, the Supreme Court Chamber considers that, in respect of the so-called super traitors, Nuon Chia had specifically admitted his intent to kill them. In relation to the other deaths and killings that had occurred, the Supreme Court Chamber considers that he had acted with dolus eventualis based on the trial chamber's findings regarding his knowledge of the circumstances in which the population movements had taken place. Khieu Samphan's intent. Khieu Samphan also challenges the trial chamber's findings as to his intent to commit crimes. In particular, he argues that the party operated under a strict principle of secrecy, which prevented him from acquiring knowledge of the crimes committed. The Supreme Court Chamber finds that Khieu Samphan has failed to substantiate his arguments. This is because he has failed to engage with the extensive reasoning of the trial chamber regarding his knowledge of the crimes, and has failed to substantiate the impacts that the alleged errors could have on his criminal responsibility. Khieu Samphan challenges numerous other findings of the trial chamber relevant to his intent. However, for the most part, the Supreme Court Chamber considers that his arguments failed to establish unreasonableness. The trial chamber did, however, err to the extent that it relied on his purported attendance of a special National Congress held in April 1975. Nevertheless, although some of the trial chamber's findings were erroneous, they do not sufficiently call into question the overall conclusion that Khieu Samphan had acted with the requisite intent. Other modes of liability. The trial chamber found that the accused were also criminally responsible for the crimes which it found to have been established based on liability for planning, instigating, aiding and abetting, and, in respect of Nuon Chi only, ordering. The accused have raised numerous grounds of appeal in this regard. However, for reasons explained in the written judgment, and given the Supreme Court Chamber's finding in relation to the accused liability under JCE, it was unnecessary for the Supreme Court Chamber to pronounce on these grounds of appeal. Sentencing. The last set of arguments relates to sentencing. Khieu Samphan in particular challenges the sentence that the trial chamber has imposed. The Supreme Court Chamber considers that none of Khieu Samphan's arguments disclose an error in the exercise of discretion on the part of the trial chamber. Finally, the Supreme Court Chamber has considered whether the fact that it has found errors in some of the trial chamber's conclusions regarding the accused's criminal responsibility should lead it to revise the sentence that the trial chamber has imposed. The Supreme Court Chamber notes that the gravity of the crimes should be reflected in the sentence. In view of the massive scale of the crimes, the complete lack of consideration for the ultimate fate of the Cambodian population, especially the most vulnerable groups, the fact that the crimes were not isolated events but occurred over an extended period of time, and the significant roles of the accused, the Supreme Court Chamber considers that the imposition of a life sentence for each of the accused is appropriate and therefore confirms the sentence imposed by the trial chamber. The co-prosecutor's appeal. What follows is a brief outline of the Supreme Court Chamber's findings on the co-prosecutor's appeal. The co-prosecutors questions the trial chamber's finding that the mode of liability of JCE3 is not applicable in proceedings before the ECCC. They seek declaratory relief only and acknowledge that the outcome of their appeal has no bearing on the accused's conviction. However, for an appeal to be admissible, it must allege errors of law that would invalidate the decision. In the absence of such a claim, the appeal is inadmissible. Nevertheless, the appeals brought by the accused have provided the Supreme Court Chamber with an opportunity to analyze the notion of JCE, including aspects which are directly relevant to the questions raised by the co-prosecutors. Security personnel, please bring the two accused to the dock. Disposition. For the foregoing reasons, the Supreme Court Chamber, pursuant to Article 4.1b of the ECCC argument, Article 14 new 1b and 36 new of the ECCC law, and Internal Rule 111, noting the respective written appeal submissions of the parties and the arguments they presented at the hearing from 16 to 18 February 2016, grants in part and dismisses in part Nunchi's and Kirsampon's appeals, and therefore, insofar as they relate to the facts carried out in the course of population movement phase 1, reverses Nunchi's and Kirsampon's convictions for the crime against humanity of extermination and affirms Nunchi's and Kirsampon's convictions for the crimes against humanity of murder, persecution on political grounds, and other inhumane acts. Insofar as they relate to the facts carried out in the course of population movement phase 2, reverses Nunchi's and Kirsampon's convictions for the crimes against humanity of extermination and persecution on political grounds, affirms Nunchi's and Kirsampon's convictions for the crime against humanity of other inhumane acts, and recharacterizing the facts, enters a conviction for the crime against humanity of murder, And insofar as they relate to the first carried out at Tulpo Chray, reverses Nunchi's and Keo Sampon's convictions for the crimes against humanity of extermination, murder and persecution on political grounds, affirms the sentence of life imprisonment imposed by the trial chamber on both Nunchi and Keo Sampon, dismisses the co-prosecutor's appeal as inadmissible, and orders that Nunchi and Keo Sampon remain in the custody of the ECCC pending the finalization of the arrangements for their transfer in accordance with the law to the prison in which their sentence will continue to be served. This judgment is issued on 23rd November 2016 in Khmer and English, with a French translation to follow. Security personnel, please take the convict to the detention center. The hearing is now closed.